pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. First order of business is, let's see, approval of August 5th minutes to August 5th meeting. Anybody have any changes or correction?
No.
Can I get a motion?
I'll make a motion.
I'll second it.
Okay, all in favor?
Aye.
All right, okay. Next thing, the meeting, next month in October, the 14th is Columbus Day. So we're going to have to meet the 7th, or the week before, if that's okay, everybody? All right, and there again, that meeting, October 7th, will be here, because October 1st, I think they're supposed to start working on the town hall, doing the renovation. So for further notice, the meetings will be scheduled, will be here. Okay. Next thing is, the first order of business is 359 East Mountain Road. This is a public hearing for a new home. Mr. Watson.
Good evening, Glennon Watson from Beatty and Watson. For Daniel Scholblin and Mimi Fortunato, who are sitting in the front row here. We're seeking a variance to build a house in the rear setback area. We have a 50-foot requirement, and we would like to place it 16 feet in, or so we have a 34-foot instead of a 50-foot offset. Now, there are several reasons for while we're doing that, most of which have been stated in the application. It does a couple of things that are important to the site. It minimizes grading through the site, even though it's longer. The grading that we would have to do to get the driveway in and approach the house would be much greater. It saves a fairly large oak tree. It keeps us back from the road and the ridge line that's up here.
Excuse me, Glenn, I can't hear you. Seems like you're taking over.
Okay. It keeps us back from the ridge line. This is a passive solar house, and it's a 900 square foot footprint. I understand that it was advertised as something larger than that in the public notice, but it's a 900 square foot, 2 stories, to give us 1,800 feet of floor area. It's passive solar house, very low energy consumption, and if you look at the topo, it pulls us a little bit out of this hill here and gets us so that we get a more direct sunlight. We're on a plateau that raises us up off the ground, and it makes it quite a bit easy. It makes our solar gain better. So we've managed to design something that stays more than the regulatory distance from the pond. It actually takes us further from the neighboring house to the south. I think that you have a letter that's been submitted to you from the neighbor who has no objection. There was some discussion about trying to buy the piece of property from the neighbor. We had a willing seller. We didn't have a willing mortgage company from the neighbor's mortgage, so that got so complicated it couldn't be done. So we did investigate that. I wanted to let you know that.
Can you move it so Brittany can see it? Thank you.
Well, why don't you do this?
Yes, thank you.
Pass those along. So basically what we've done here is we found on the site, we found the place on the site that would require the least amount of grading, least amount of excavation. It would allow the best solar gain for this house. What's your energy efficiency? You're going to
Use 10% of conventional
So
10%?
10% of,
10% of the energy use of a conventional house.
10% off convention.
Yeah, I couldn't hear the 10.
Right.
right, 10%, and I wasn't sure of that number. But as we move back into the building, we get behind this hill, and we'll lose some of that gain. And again, we don't believe we have any effect on the neighbors. Most of the houses are across the street and down a little to the south. There's a couple of houses to the north, but they're at a considerable distance, well over 300 feet. We have approval of the health department, and we're hoping that you see your way clear to give us a variance so that we can build this really responsible building.
I guess you're looking for it's a 50-foot setback. 50 feet is required, rear yard, and you're 34 feet 7 inches. So you're looking for a variance of 15 feet 5 inches. Is that correct?
That's correct.
Right. The building on the bottom, that's the garage?
Yes.
But that's going into the hill, that's being built into the hill?
That's going to be built a little bit into the hill, yes.
Yeah. I looked at the property today. I saw it. It's a pond, like I said, right back there somewhere, right? On the north side, right? Okay.
Pond is here.
Right. Okay. And I saw it, the reason it had to go further back was because of the steep grading in there.
The grading in here gets difficult, especially to construct a house. That's just north of the tree. And we could very, very well lose the tree in that grading process, and we don't want to do that.
Correct. And the letters from, let's see, the letter we received was from a neighbor, Jay and Joanne Donzella, I guess, they're at 349 East Mountain Road South. And they say that we agree that Ms. Fortunato and Mr. Shilbin's proposed home location is the ideal one for the placement of the house, as it will cause the least disruption to the natural environment. We will confirm that this plan will not negatively affect our quality of life and are in favor of the variance being granted.
And just so that owner, that letter came from the owner
Right there.
along the south and the west line, so we're going closer to their line. They wrap around the back of this piece of property.
Okay. I looked at everything. Does anybody have any questions so far on this? Any questions? No? All right, well, let's just go to 5 factors and see where we're at on this here. All right, first factor is, what possible detriment would the variance have on nearby properties? There would be no detriment to nearby properties, although the house would be constructed nearer to the east of the line of the appellate's property and thus nearer to the neighbor's property. It would be further from the neighbor's house, which is located to the southwest of the location. Well, we got a letter from the neighbor that it's okay, so that kind of takes care of that one. 1B, what impacts would the variance have on the character of the neighborhood? There is no expected impact on the character of the neighborhood because the lots in the area are relatively large, making the shift almost imperceptible to adjoiners. There's unlikely to be any building to the east of the property. Others in the area have not received similar variances. Other structures in the neighborhood are located mostly across the southerly East Mountain Road. If you didn't get the variance, how else could you build what you want to accomplish your goal? The appellants could move their home to the west and avoid the need for a variance. However, as discussed above, the amount of excavation disturbance would be greater. So I could understand what you're trying to say. Not only that, you're trying to get to the solar.
The solar,
thing,
and
which
that,
everybody's looking-
frankly, that should have been in that. The mention of the solar should have been in that.
Right, okay. Let's see.
I think the page got out of
Yeah,
order.
I got it out of order, all mixed up there. All right. What impact or effect would the variance have on the current physical and environmental conditions in the area? Granting the variance will not increase the effect physically and environmental conditions of construction of the new home. It will have the opposite effect. It will reduce the need for excavation and grading. Construction of a new home will involve paving and unpaved surfaces. However, the increase in paving is to be a result of granting the variance will be minor. I agree with that. I think more than the paving is less important than taking out the, grading and all like that, removing all that There would be trees too, I guess you would have to take out. Yeah, right, okay. 5, is the variance resulted as a result of self-created hardship? The variance requested is not self-created. The applicants are seeking a variance to reduce impacts associated with building within the setback lines. There is no need of variance where the applicants purchased their land. But I guess upon looking at the land and the site plan and everything else like that, this was the best place to put the home because of the, not only the solar issue, but the excavation issue.
Disturbance
Less
issue,
excavation.
yes.
Anybody have any questions on this?
Yeah.
Application? Go ahead.
That's a long driveway. Where's the runoff going? Where is there runoff from that driveway? How long is the driveway?
Oh, good Lord. Here it's 200, so I'm going to say it's about 350 feet.
So where does the runoff go?
It'll shed to the north,
Go ahead.
and it's banked so that it'll not accumulate, it'll sheet flow.
Is it going out onto the road?
No, we're much lower than the road.
I apologize for being late, and I may have missed something. But my question is, there's a lot of land there, and I'm wondering. I mean, I heard that your concerns are solar. Are you planning to have solar roof?
Mm-hmm.
And is it a large solar installation, or
Well, it's not
passive house.
just the.
Would you come up to the mic? You come up to the mic.
Stop and tell us who you are.
Mimi Fortunato.
Okay.
Hello. And so we're working with an organization in Maine called Go Home Logic. They create passive homes. And the purpose of using that organization is to create a home that does not use electricity, but that creates electricity. So although the property does seem expansive for a modest home, when we walk the property, you really see that there is only one flat area in the property that would give us the opportunity to receive the most solar gain and to also create the least disturbance to the natural environment, particularly the larger trees that we do not want to damage or cut, and the historic stone walls. So somehow in walking the property, one feels that there is just one spot to place this home. And perhaps there was a home there 100 years ago, or a barn, or some structure there, but it is the only spot on the property that has the criteria, that meets the criteria that is needed in order to create this really small home, but that will, rather than disrupt the landscape, will become part of the landscape in a very natural way.
And are you going to have? Are you going to run the home solely on solar?
Well, Daniel Scheiblin. This is actually, it's a paradox. We could have solar panels, or we could have geothermal. And now, as we discussed it with the architect, they said this house uses so little electricity that it almost doesn't make sense to have solar panels on the roof, because the way it's built, it's a very airtight shell, so it uses like very little electricity. Basically, you can run the house on like $300 for electricity a year. So if we would have a solar panels, we basically would overproduce and probably would have to put it back in the net because we don't even use it. Mm-hmm. So it's really an amazing new way of building a house, and so we could have solar panels, but right now it's actually not even included.
So what will be your source of electricity then?
It is outside world electricity unless we put in the geothermal thermal.
Okay, so it's
have to have solar panels. Right now it's not in the plan.
okay. I thought I heard that you wanted the house where it is because of the ability to have solar there.
The sun.
It's the way it works is the larger window faces south, and the smaller windows on the west and east are basically they're small to reduce the energy loss, and the larger windows on the south side, so they get the energy. So literally the actual sunshine warms up the house or brings in the energy.
Passive solar.
Yeah, it's a passive solar in that way. Yeah.
Any other questions?
I should point out just one other thing with regard to your comment about the size of the property. There, at the west end of the property, there's a protected ridge line, and so we could apply to build there. You're not disallowed from building there, but you're certainly discouraged by the code. So we're trying to, so we do get some loss of practical loss in terms of that because of the ridge line.
Right, and you, where you're building, it's facing Fonstock?
This is actually to the southwest, yes.
Yeah, okay.
Any other questions? Any questions? Okay. It's time to call for a roll call vote on the...
No, you haven't invited the public to speak yet.
Oh, I'm sorry, you're right. Anybody from the public want to speak on this? Yes. Step over there, please, sir.
Good evening. My name is Charles Nolan. I live at 362 East Mountain Road South, which is right across the street from 359, the building lot. Thank you for your time to listen to me. I'm in support of the variance before the board for Daniel and Mimi. I've gotten to know them, and I feel they would be a welcome addition to the neighborhood. I believe that they're going to build a beautiful home.
Okay, thank you very much.
Okay, thank you very much for your
Thank you.
time.
Thank you. Anybody else want to speak towards this? Yes, sir.
I'm Richard Butensky. I represent Bilberry Farms, which are the owners of the pond. So I got to meet the applicants, but my neighbors didn't, but they are relying on feedback from me. So so first thing, what I'd like to say is that I have the original plan for that house was built near the road. There was a house built near the road. So it could be built with actually less disturbance, but we don't want to stand against this. We actually understand why they would want to build the house where they are. And despite the fact that actually there'll be more possibility of noise disturbance to where we enjoy the pond, and possibly more site disturbance for us than where the house originally was from a prior owner of this property. And we don't have any concerns at all about this particular applicant. They're lovely people, and if they live there for the next 50 years, where we have we'd be happy. But, of course, they may not be there for 50 years, and anybody else. So we're just wanting them to make sure that this board looks out for the pond and for what we have here. So the original, we know, because I actually have the plan, because I knew the first owner of this property after it was subdivided, or it was the second owner. And the septic was in the same place, and they were using a significant amount of fill was required but for the septic system that was designed by Beatty and Watson. I've been told that that's not the case now. Now maybe they were mistaken, and maybe it is, or maybe there's some sort of new design for the septic system that I don't know about. But my concern is, I don't know why that fill was required. I know nothing about septic systems, but I just, I should say we, because as I'm representing Bilberry Farms. We are concerned that we just want to make sure no corners were cut, or accidents, or anything was done accidentally that would leave out this fill, or maybe it was a mistake before, but there was $20,000 worth of fill that was originally designed to go into that system. And so is there, Phil?
When you finish, I'll get to him.
Oh, okay. So I guess I just want to know if that's the case now. So as long as that's taken care of, and as long as, I don't know how it's guaranteed. I'm not really concerned, or we're not really concerned about these folks having any noise issues, but we are concerned,
They'll
like.
look quiet. They'll look like quiet.
Yeah, no, they'll be fine. They'll be fine, but they may not own it.
You're not partiers, are you? Not partiers, are you? Okay.
But they may not own it. They may not own it 5 years from now.
All right, I understand.
And so, where compressors might be placed, where things like that. So, I don't know what can be done with that. I don't know if that's within your purview or how that works. But we just want to make sure this is a preserved area that we use strictly for. We've never built anything there. We just use the pond for canoeing and fishing and whatever we want to do, and pretending that we're in the middle of the woods by ourselves. And we'd like, to the best possible way, we don't want to say that these people shouldn't get their variance. We'd like them to get their variance. I understand why the original housing site, which I believe was over here somewhere, why this would be a superior site for them. But we just want to make sure that whatever can be mitigated for us is mitigated, and that the septic does not pollute our pond.
Right. Well, I think the house has a small footprint. It's not really it's not a McMansion type of house, is what I'm trying to say.
It's a
and
lovely
if they're
little
going
house.
with the solar passive thing, so it means that I'm sure they're cognizant of the environment and all like that, you know what I'm trying to say, so.
No question.
Right, and like I
No
said,
question.
they don't look like partiers, so.
No. There's no question that they're environmentally sensitive people, and
Right.
that they want to do the best thing. However,
I'm gonna have Mr. Watson explain the septic system to us.
right.
Okay?
Okay, thank you.
Thank
Excuse
you.
me, you said there was a former house there?
No, he said it was.
No,
No,
Right.
there's a former, this is the original plan
Okay, so
for the
that was
house that was
planned where
going
the
to be
house was
there.
gonna be.
There was a house plan there with a
Okay.
septic system in the very same spot.
Same spot.
Yeah, and it
Thank
was, so,
Thank you. Mr. Watson, can you explain the septic system to us for this gentleman's concern?
Well, I can tell you a couple of things, and the size of the septic system depends on the number of bedrooms. I believe that I would expect, I do not absolutely know without checking, that the number of bedrooms in this house is smaller than the other bedrooms. The other thing is that the Putnam County Health Department, or I think it's actually the state of New York, has reduced the expected flow out of a bedroom from 200 gallons out of a house, from 200 gallons per bedroom per day to 150. So that cuts the flow into a septic system by 25%.
Right.
So we have fewer, I believe we have fewer bedrooms. I would have to check that, to be honest with you.
Okay.
And we have we have less flow. The reduced flow has to do with basically water saving devices, low flush toilets, different things like that. So there was logic, and it's in my 40 plus years of dealing with the health department, it's the first time the regulations got easier. So basically, and I'd have to look further, but it's a little bit speculative on my part, but we have a smaller system, and we don't, because of those two reasons, and we don't need as much fill in order to need fill to construct it. That being said, the health department, has reviewed it, does see it being installed, looks at it when it's open, when people can see that the parts are all there, and they require an engineer's certification with regard to the way it was constructed, and that it was constructed in accordance with the plan. So that's the main reason.
Do you have a approved permit from the county?
We do have that, right? We have the health department, right? Yeah, we have the health department permit, yeah. I don't handle that in the office, so I'm not always sure, but yes.
If you get the variance, you have to go back to the planning board, is that what you're?
We have to go back to the planning board for site plan approval,
Site plan
yes.
approval, okay.
And we've applied, and we're in abeyance until we have your decision.
Okay, thank you.
Thank you.
Anybody else want to speak on this? Any other questions from the? I'm going to take a roll call vote on it. Mr. Justone, how do you vote on this application?
I'm
Sorry,
sorry.
vote on the application? Great. Granted?
We didn't do the closing of the public hearing, did we?
Oh, make a motion to close the public hearing?
I'll make the motion.
I'll second.
All in favor?
Aye.
Okay, motion approved.
I
Okay.
vote to approve.
Vote to approve.
I'll vote to approve.
Mr.
I vote to approve.
I vote to approve as well.
I vote to approve. Okay, thank you.
Thank you very much.
Any extra electricity, send it my way, okay? I could use it for my door, all right? Okay. Okay. All right, next order of business is, let's see, 29 Travis Corners. Robert and Susan Freeman. Robert and Susan Freeman? This is, I'm going out of order,
This is just
just an application approval.
completion.
Yeah.
How are you? My name is Robert Freeman. I'm the owner of the property. We're seeking a sideline variance for an addition we want to put on our house,
Okay.
a family room addition. Right now, our house is already a non-conforming piece of property. We're already encroached upon the sideline setback at 27 feet 10 inches, where it's supposed to be 30. We're trying to get it down to 21 feet, so I'm looking for a 9-foot variance. My addition is for the family room. It'll be right off my kitchen. It's going right in the place where my garage is now, and I have a deck outside on top of the garage. So this would be, I would expand it. Right now, the garage and deck is 20 feet by 16 feet, or 14 feet. I'm going to go to 20 feet by 24 feet. Then take the deck and expand it over the rest of my parking area that I have there.
This, tonight is just for completion, okay? Let me explain to you what we do. We look at the, for tonight, and there's no public input on this.
Right.
And to see that we have everything we need to make a decision, then we're going to set you up for a public hearing
Okay.
for next month, okay?
Great.
I just one question. I passed by. You have a neighbor pretty close to you on the other side. Right, not-
Stafford's right here. Yeah,
Yeah.
they're about 70 feet away from
Yeah,
my-
do you know them?
I do. Betty and
Okay.
Frank Stafford.
For your public hearing, if you got a letter from them or something like that, you know,
Okay.
how that they would have no objection, it would help you.
Okay, how about the neighbors in the back, Kat Guthrie? She's
Any
probably...
letters, that'll help you.
Okay, all right.
If you got a neighbor who's gonna go against you, don't get it, you know, don't ask them. I mean, anybody who's for you, definitely.
Okay.
Okay. I looked at the application, it looks complete, everything is there. Did the building inspector tell you to, you know, give you a list of things that you need and all, right?
did, yes.
Yeah,
Yeah.
he did. That's helping us a lot, that's for sure.
Building inspector, my architect, Justin.
Yeah,
Kuchar.
I think everything is here. Does anybody have any questions, or think anybody's missing on this application? Okay. And at this time, I'm going to call for motion that the application is complete, accepted.
I'll make the motion.
Second?
Second.
All in favor? Aye. All right, okay. Your application is complete.
Okay,
Okay, now you're going to come for a public hearing October 7th.
October 7th, okay.
October 7th, it's going to be here.
Okay,
Okay. Our secretary will mail out letters. You gave the addresses of your neighbors and all like that.
Right.
Right. She's going to mail out letters to them that, you know, you're doing this, okay? So they notice they have a chance to come here and speak and say their opinion. But like I say, in the meantime, if you can get some letters of you know, just people who are for your idea, that would be help you.
okay.
Okay, thank you very much. Okay. Next order of business is application approval for 267, 269 Avery Road.
This is also just for completion.
Okay.
How you doing?
Introduce yourself, please.
I'm Michael Reap. I'm the architect. I'm doing this addition for the Lansburys.
Okay.
I'm representing them. The variance they're looking for, they're proposing a screen porch off of the guest house, which the guest house is completely not within the setbacks.
Right.
And so the porch to attach to the house would have to, requires a variance to
Yeah, you're looking
to
for
be using.
a side yard setback variance.
Yes.
30 feet is required, and you look for a setback of 15 feet, so you're looking for a variance of 14.7 feet.
Yes.
Is that correct? Okay. Like I say, tonight's meeting is just for to make sure you have everything, if we need anything, any other information. It looks like it's complete, the application, I went through everything. And, like I say, the town building inspector and the secretary has been really helpful in giving everybody the information that they need to get things together. It's made it a lot easier for us. The same thing, again, it's going to be a public hearing. If they have any neighbors who's, for them or something like that, or, if they would give a letter or a peer or something like that, that would only be helpful. And we always want to know what the neighbors around, who it's going to affect. Although I don't know who it's going to affect there, because I passed by there today, it's by New York State aqueduct.
Yeah, the aqueduct goes
Yeah.
through, that's.
I couldn't even just about
where-
see the house from the street.
Yeah,
So
exactly.
That's right. So, all right. So, any questions? Any board members? All right, at this time, can I get a motion to approve application? All second? Second, okay. Glenn, you seconded? All right, all in favor?
Aye.
All right, okay, motion approved. Back here, October 7th, same 7:30,
Okay.
and it'll be a public hearing.
Okay, thank you.
Okay. Takes care of that. Next order of business is a public hearing for Ricky and Mark Ventura, 1 Lane Gate Road.
Good evening.
Good evening.
My name is Michael Surignano. I am Ricky Ventura's attorney. And Ricky, along with his brother Mark Ventura, own this 9.52 acre site on the southwest corner of Route 9, a state highway, as you know, and Lane Gate Road. The property is currently zoned Highway Commercial, HC. This is...
You have to turn it this way, because
Yeah.
I can't see it.
Okay. This is an area map. This is the site here. Everything in yellow is HC zoned under current zoning. To our north, there are 13 other parcels zoned HC across or to the north of Lane Gate Road. To our east, across Route 9, there's a 72.91 acres site zoned office, commercial, industrial, mixed use, OC. And 2 parcels to our south and west are zoned rural conservation, RC. Before I describe the nature of this appeal and the relevant history of the commercial use historically of this property and the applicable law, I wanted to briefly address the May 2nd, 2016 court ruling that Mr. D asked about when we appeared last month.
Which court ruling is that with from
That's the town
Justice Court?
Justice Court,
Okay,
correct.
Sure.
And it's, as I said last month, I'll say again, that decision is not binding on your board, but it is informative in several respects. First, the court only heard from 2 witnesses. The code enforcement officer, Kevin Donahue, testified on behalf of the government on prosecution. And he told the court, interestingly, that he never made a determination that we're asking you to make, which is whether the processing of vegetative material, construction and demolition debris, soil, dirt, gravel, rock, including rock crushing, and stockpiling of processed material on the site was a lawful prior non-conforming use. Mr. Donahue never made that determination, and he said so to the judge. And of course,
Well, we'd have to look at that record to see.
yes.
Yeah.
All right. The court also only heard testimony from one defense witness, and the court found that testimony alone inconclusive. In contrast, tonight, we are submitting corroborated and documented evidence by sworn affidavits and/or live testimony of not less than 8 eyewitnesses, and photographs and invoices and other documentary evidence. So what I want your board to understand is not only is the court decision not binding on you, but you're going to have a much fuller, more detailed, I believe, conclusive record before you, one that was sorely wanting before the judge. And I think if the judge had the record that you're going to have, there would have been a different determination there. But that's now history. We were fined and we paid it. The second thing I wanted to talk about with respect to that court proceeding, that the criminal charges in that case were intentionally drafted by the government prosecution to keep the very issue we're asking you to rule on, the legal non-conforming status of the property, from even being reviewed by the town court. How do we know that this was the prosecution strategy? Because the code enforcement officer said so in emails to the town prosecutor that we obtained through a FOIL request. Now, I'm going to hand out a record. I've given Tara a copy, and I have a copy for each of the 5 of you. I apologize sincerely for not getting it to you sooner. It's voluminous, but we had to get FOIL request information. We had to dig out old records, and it took us a lot more time. I don't expect this board to read everything I hand you tonight or to make any decisions tonight. I understand that fully, so let me hand that out.
Giving us some homework to do, huh?
Yes. Well,
You know, it's the volunteer board, right?
I understand. I understand, but Ricky Ventura's
I understand.
property rights and livelihood are at stake here.
I understand completely.
All right, so let's go to Exhibit 25. And this is very interesting what the prosecution strategy was. You have an email from Mr. Donahue to Bob, number 25. You've got it. You're right. You're on. That's it. Mr. Lim, you've got it. So you've got an email from Mr. Donahue to Mr. Sinkway.
Okay.
Bob, for your review, need to draft a complaint for the court. Below is the zoning text. Call me to discuss options.
Okay.
Okay? And basically what he's citing is the portion of the code that says if the zoning officer serves you with a notice of violation and you don't cure it, that's a separate crime. That's a separate violation, separate and apart from whether the underlying problem was a crime or not. So very smartly, and that's signed by Kevin Donahue, that email. And then the next document is dated 11/7/2013, and that's from Mr. Donahue to Mr. Cinque, and he says, Bob, it's this page right here. It's part of the same exhibit.
Yeah. Okay.
Okay?
Yep.
Please review my information. Information means the charges. The information in the complaint is based on not complying with the notice to keep the substance of the activity in violation from review by the court. So very shrewdly, the prosecution laid the groundwork, and it's good lawyering. They laid the groundwork for serve a notice violation, and now we're going to prosecute you on failing to cure the violation, as failing to respond to the notice of violation, as opposed to whether or not there's a legal non-conforming use. They didn't want the court to review that, see, from review by the court. So there was an intentional strategy here not to have the Justice Court really hear the issue that you're going to hear and decide on the merits.
I have a question.
Yes.
Last month, when you were here, we asked you to provide documentation that this was ever legally
Right. It's there.
permitted. And I don't, is that in here?
Oh, absolutely, in spades.
Where is it?
You've got sworn affidavits under oath, under penalty of
No,
perjury,
no, I
from
mean-
8 witnesses detailing the historic use of the property.
I'm talking about documentation of the original, it wasn't a zoning law, but original 1983 document that.
Yeah, I've got it all in there. It's all there, and if you give me a minute, I'll get to that.
Right.
Okay.
Okay, all right. The last thing I want to talk about with respect to that court prosecution was that the court took judicial notice that no appeal from the 2013 notice of violation in order to abate was taken to your zoning board in a timely manner. So unfortunately, Ricky did not avail himself then as he has now. He did not appeal that original 2013 notice of violation to your board to get an opinion back in 2013. Had he done that and had it been properly presented, I believe this issue would have been resolved back in 2013.
We had a number of years back, this was presented, it wasn't presented to us, but it was given to us and never went forward.
You have a good memory. You, and I'm not faulting you, you were right. You decided not to hear that appeal because there was no underlying order that was being appealed. It was a request by Ricky's prior lawyers to put the issue in front of you, and procedurally it wasn't properly before you.
Okay.
And advice of counsel, and I'm not faulting you, you were right. That's the law.
All right,
You
that's
can
good.
only
Thank you.
appeal a determination from the building inspector. But tonight we stand before you, having filed a timely appeal of a new and distinct and appealable determination and order made by Greg Warner, the current zoning enforcement officer and zoning administrator. So let's go to Exhibit 1, and I have a blow-up of it. Here's the stop work order. And the stop work order says that the code of the Town of Philipstown, section 175-50B, quote, prohibits the processing of soil, dirt, gravel, and rock, including rock crushing, in all zoning districts south of the intersection of East Mountain Road South and Route 9, close quote. I happen to agree with that. The law changed long after these uses were legally commenced. Then it goes on to say, you are ordered to answer or correct this violation to the satisfaction of the zoning administrative officer by 1, cease and desist immediately the use of the property for processing vegetative material, demolition and construction debris, soil, dirt, gravel, and rock, including rock crushing and the stockpiling of the processed materials on the property immediately. That's an erroneous decision. That, because it goes to the essence of this case, which is that all of these activities are indeed going on, have been going on since 1979, and they are legally non-conforming, and they have been grandfathered. So that's the decision that is before, that we are appealing to you. We're here on a new appeal that's separate and distinct from the court proceeding, separate and distinct from any prior applications made to your board.
Just to clarify, are you saying that the use that you're claiming predates the current code, commenced in 1979?
Absolutely. Okay.
And also, just to clarify, the stop work order was issued based upon 2 items, correct? It was that the use is not permitted under current zoning.
Correct. That's
and the second one is the use is not in conformity with the planning board site plan.
Correct. Both of those were cited. The second one, whether we conform to the site plan, is really not the purview of this board.
Well, you're appealing that order to this board.
I'm appealing.
And one of the grounds for the stop work order was nonconformity with the site plan.
Well, I don't believe that what we're doing currently on the site is a violation of site plan.
Understood.
But when this board, I believe, based on the record that you have in front of you, and I'm going to take you through as efficiently as I can, once you've reviewed this and you make, I believe, the correct determination that this is a legally non-conforming use, the site plan issue really is a sideshow. We'll go, if we can't reduce the pile or move the pile to match the site plan, we'll go back to the planning board and get an amended site plan approval. The critical issue here is whether or not this is a legal non-conforming use. And that's what I want to get to now.
So just so I'm clear, and I don't mean to interrupt, have you asked the planning board to either for an amended site plan or to confirm that the use that you currently have conforms with the 1983 site plan?
Not yet.
Okay.
No, we appealed to this board because, as you know, the clock starts ticking from the moment the order is issued. But as the board well knows, under Section 175-59A, you are empowered. You are given great powers to correct what we believe is an unjust stop work order. And that section states, the Zoning Board of Appeals may reverse or affirm, wholly or partly, or may modify the order, requirement, decision, interpretation, or determination appealed from, and shall make such order, requirement, decision, interpretation, or determination as in its opinion, your opinion, ought to have been made in the matter by the administrative official charged with the enforcement of this chapter. I'm continuing the quoting your statute. In doing so, the Zoning Board of Appeals, you folks, shall have all the powers of the administrative official from whose order, requirement, decision, interpretation, or determination is taken. In other words, you now, the five of you, collectively sit as the code enforcement officer of the town of Philipstown. And we're asking you to give this a second look, to keep an open mind, hear our evidence, and make what we believe should have been the correct determination that was made incorrectly, and find that this is a legally non-conforming use.
Okay.
Now,
Just for your information.
yes.
This board has overturned a code enforcement officer once before, so it's not uncommon for us to overturn it, okay? If we feel that that's the reason, if there's a reason for it.
Well,
I'm saying this wouldn't be the first time, is what I'm
okay,
trying to say.
I'll guess that usually occurs in the context of a variance, perhaps.
No,
Maybe
this is a violation.
Okay, all right. So let me just give you a brief history, take you through it. August Ventura, Ricky's dad, acquired the property on February 2nd, 1979.
Before you start that,
Yes.
1 second. You gave us the town justice tour. Would you like to go over the appellate terms? Do you have copies of that?
Well, no, I do have copies of it, but
Can you give us
I don't
copies
think.
of it?
I'm
you
sorry,
give us
did I give
copies?
it? I did not.
Could you provide us with copies of it?
Absolutely, I'll give that to you.
Provide us with that, so I'd like both court decisions. That would only be fair for us to look at.
All right.
Okay, go ahead.
I can't complain too much about either of those decisions because they were based on a really insufficient record.
Okay.
But anyway.
But we needed to consider this.
Yeah, no problem. I'll get that to you before next meeting.
Sure.
So Ricky's dad, August Ventura, acquired the property on February 2nd, 1979 from Anastasia Farms and Stables, Inc. The property was then zoned industrial, I. The elder Mr. Ventura, who operated a contracting business, immediately began utilizing the property to receive, store, and process C&D materials, construction and demolition materials, C&D, and organic land clearing materials. He then sold, after processing them, he sold such processed materials for off-site construction projects, his own and others. On May 19th, 1979, Mr. Ventura applied for a permit to, quote, use premises as a contractor's yard and garage, close quote. All right, that's Exhibit 3 in your package, and I have a blow-up. And so here we are. Application for building use permit. August Ventura. It's dated May 19, 1979. Proposed use of property and/or structure, and handwritten, it says use premises as contractor's yard and garage. The lot area, 9.471 acres. And if you look at the next page, it says application approved, and it's checked. And it's dated, the approved date of approval, 5/19/79, and it's signed by the building inspector, Town of Philipstown. So.
1 second, let me just look at that.
Yes.
Okay. I don't see anything about rock crushing. I just see a contractor's yard, correct?
Right. Well,
Okay.
contractor's yard, and I'll get into this a little more later. Contractor's yard is not defined in this 1968 code. Nowhere in the code is it defined.
I understand that.
Okay.
Also
And back,
mentioned on your application that you were,
well, because.
gonna be crushing
you'll-
rock.
And I'll show you in a minute. The 68 code had classifications of different uses, and a contractor's yard was one that was specifically noted under 39. But back in 1979, the terms C&D processing facility, solid waste facility, waste management facility, they were not yet in vogue. But the 1968 code, in effect, did permit a contractor's yard. It did permit the outdoor processing of goods made from concrete or asphalt, dirt, gravel, and rock crushing in an industrial district. And that's what this property was.
was processing defined?
No.
What processing is?
No, processing wasn't
So it
defined
could be
either.
anything, couldn't it?
It could be, and when there's a doubt about the, or any ambiguity in a zoning code, it's got to be resolved in favor of the property owner, not the government, because the government is the one out trying to take away our property rights. So the courts have, our Court of Appeals has always held, if there's any ambiguity, if there's a lack of a definition, it's got to be in favor of the property. It's like the tie goes to the runner at first base. The property owner gets the benefit of the doubt. That's the law because of the constitutional implications.
Okay, so it talks about the use as a contractor's
Right.
yard. Where is the definition of a contractor's yard?
It's nowhere in the 68 code, and that's the town's problem, not Mr. Ventura's. Okay? All right.
Okay, but,
So, the building inspector, oh, I'm sorry.
but it doesn't prove that, that this land was approved for rock crushing.
Well, I'm going to get to that.
All right.
Okay? All right. So the building inspector approves the use permit application on May 19th, 1979, and then thereafter, this approved permit was repeatedly renewed and approved beginning on 7/7/80, 10/17/81, 1/12/83, 1/13/84, 1/18/85, 1/11/86, and 7/7/87. Look at Exhibit 4. 8 separate times, you'll see in Exhibit 4, over a period of 8 years after this permit was approved, the building inspector kept certifying that August Ventura's use of the contractor's yard and garage, quote, will comply with the requirements of law, close quote, and reissued the building permit year after year after year for 8 years in a row.
When did the rock crushing start?
Almost immediately after he purchased the property. We have affidavits that from 8 different individuals with personal knowledge of the site, and those are exhibits. I was going to get to that later, but here it is. It's Exhibit 17 through 24. There are affidavits, detailed affidavits from eyewitnesses that take us back as far as 1980 with rock crushing, with soil processing, screening, with rock crushing, and so you'll read those between now and next month. I don't know that we have to read them into the record. Okay. All right. So, but what I want you to know is when you look at the 8 renewals during that first 8 years of the site, and you look at the affidavits, what the building inspector was witnessing is what these eyewitnesses tell you, which is these processing of organic and inorganic materials were going on, and he kept certifying that it was complying with the requirements of law.
You
Now,
say it's from 1980 on. He's been
but the
crushing-
affidavits, we go back as far as 1980.
So he's been crushing rock for the last 40 years there?
Well, his dad has now passed away, and
But
Ricky.
Ventura or whatever.
The Ventura
They've been
family.
crushing rock for 40 years there?
Yes, not every day, not every week, and they didn't always own the equipment. They would, when they accumulated enough rock, they would rent or lease a machine, and you have the leases. Your questions are very good because you're taking me out of my order, but that's good. We've given you the leases and the processing, crushing, machinery, and equipment invoices. That's number 15. Okay, item 15.
Exhibit 15 or?
Yeah, Exhibit 15. And so what would happen is August and then Ricky, when they would accumulate enough rock or enough dirt or enough organic material, they would rent the screener for a month or a week. They'd rent the rock crusher, and they would do that. So this has been going on continuously.
But not at the volume that it is today.
Well, true. But volume, an increase in volume isn't necessarily.
That's just a
an
question.
Yeah, no.
Question.
And
Is that correct?
That's correct.
Okay. That's all.
That's fair. That's a fair statement. But that doesn't mean that it's illegal.
No, I didn't say that.
Okay.
I just asked you a question.
Yeah. All right. Now, in 1983, the elder Mr. Ventura obtained site plan approval. Went to the planning board. He had all his permits. He was doing his thing, but he wanted to do other things. In addition to the rock crushing and the soil processing, he wanted to do some additional things. He wanted to run an auto parts retail store. He wanted to run an auto body and repair shop. And he wanted to do any accessory uses customary and incidental to those uses. So go to Exhibit 7. I've got a blow-up of that. Okay. So Exhibit 7 is the resolution of the Planning Board of the Town of Philipstown. It's Resolution PB number 16-83, dated 11/23/83. And I'll just read a couple of sections highlighted. Whereas the Philipstown Planning Board has received from August Ventura an application for approval of site plan dated 7/9/83, which application pertains to a 9.471 acre parcel of land located on the south side of Lane Gate Road and the west side of US Route 9 in the industrial district, and where existing buildings are proposed to be renovated for use as A, an auto parts store, B, auto body repair, C, contractor's yard, maintenance and repair shop, and D, a warehouse and storage area. All right, drop down to the whereas is number 2. The site plan has been augmented and clarified to meet the submission requirements of the zoning law. Number 8, the site plan proposals, as revised and updated, are in substantial compliance with the zoning law. You will see from the affidavits, you will see from the photographs, you will see from the equipment leases that prior to 1983, all of the issues, all of the processing that's become an issue before the board today were ongoing at the time this planning board approved the site plan.
We can't, I understand what you're saying, but I can't speak for the planning board.
I'm not asking you to. I
Okay.
just want you to know that the planning board, knowing that what we were doing on the site historically, they've said that the proposals, as revised and updated, are in substantial compliance with the zoning law. They also found that under SEQR, the State Environmental Quality Review Act, the application is unlisted because it will have no significant impact on the environment. And so they adopt that resolution. So now, not only in 1983, does August Ventura have his approved permit for a contractor's yard and all of the incidental accessory uses. He's now got site plan approval to do what he had been doing and to do some other things.
Okay.
It turns out he didn't really make a go of the auto body and those aspects of it, and he continued the contractor's yard and basically the recycling operation.
So the planning board gave approval for a contractor's yard, and there is no such thing as a contractor's yard. Is that what we're saying?
A contractor's yard was already approved, but they now gave him additional uses, kind of a mixed-use
But
site.
we already gave testimony that there is no such thing as a contractor's yard. I'm
I
trying to
didn't
find
say that.
how do you-
I didn't say there's no such thing.
I
I
thought
said
the
it's
judge
not
said.
defined under your code.
Okay, so that's what I'm saying. How could they give permission if it's not defined in the code?
Because when something is specifically listed as a permitted use, but it's not defined elsewhere in the code, it's up to normal usage and interpretation.
Okay.
Okay? All right. So after the 83 site plan approval, Mr. Ventura continued to use the property for processing, crushing, screening, storing, and reselling C&D and land clearing organic materials. And he did so without interruption until his death in February of 2002. His sons, Ricky and Mark, inherited the property and the business. And on February 2nd February 11th of 2004, they took a title to the property through an executor's deed, which you have as Exhibit 8, and they lawfully continued such uses without interruption up to the present. Now, as you know, under Section 175-25B of your code, a change in ownership or possession, quote, shall not affect the right to continue a non-conforming use. So the fact that August died and his sons inherited the property did not in any way change the legal non-conforming status of this property. In 2011, Ricky and Mark filed an application to go back to the planning board for site plan approval or amended site plan approval. They paid a $900 fee. They made a $5,000 escrow deposit. That's Exhibit 10. And they appeared before the planning board seeking to amend the 1983 site plan, mostly to construct a new access directly from Route 9, further south. The minutes of the March 24th, 2011 planning board meeting document the legally non-conforming use of the property to store and process earth and organic materials, topsoil, mulch, compost, and some construction material in the form of asphalt and concrete recycling, which was used to produce item 4. So I refer you to...
here?
Yes.
Where-
Yeah, that is Exhibit 10, and I have a blow-up.
Yeah, but that specifically says for storage?
Yeah, it's, the site plan is, was done by Lawrence Piaggi. It's dated February 2nd, 2011. It's called Amended Site Plan for Ventura, and it shows a new entranceway off of 9, and it shows, you know, a more organized storage of materials.
The application, does it specifically say storage or more than storage? You mentioned storage, there's a storage area.
Oh, yeah, look at the...
I'm trying to look, I got some book you gave me.
10,
Yes.
Exhibit 10.
Good question. Let me get to it. Exhibit
Next
10.
page down.
I'll read it to you. If you look at the proposal, what is the proposed use of land or buildings? And it says, please refer to attached description, which I'll come to. And then drop down to C. Is any outside storage proposed? Answer, yes. Describe. Equipment used for processing inbound stockpiles and material stockpiles. And it, again, refers to the description. So let's go to the description.
Okay, but it says equipment used for.
Right.
It doesn't say that you can process it. It says equipment used for.
Everything is referring to this description. So go to the description, statement
Sure.
of use, general statement of use.
Which one is that page?
A couple more pages back.
Okay.
Okay, you got it? It says Ventura Property, it's a little difficult to read. Ventura Property owns a parcel of land in Zone Industrial, Zone I, and operates it for industrial purposes. It uses the land as a site for creation and recycling of materials, including the following. And they're bullet points: storage of equipment in conjunction with the movement of building and organic materials, temporary storage of construction equipment used at construction sites, to process topsoil and sale of mulch, compost, and related products, use as a contractor's yard. And then a crusher has been brought onto this site on average of 3 days every 3 to 4 months. It operates on weekdays only from 9 a.m. to 3 p.m. with a 45-minute break from 12 to 12:45. And then drop down to the...
Wait.
Yes.
Before we drop down. It says the crusher has been brought onto the site for an average of 3 days.
Correct.
For 3 days every 3 to 4 months.
Correct.
Okay, it doesn't say, right now, when I drive by it, I see it as a constant operation.
Right.
I mean, not 3 days every 3 or 4 months.
Right.
And do you agree with that or disagree
This
with
is
that?
in 2011.
No, I'm asking you about this here.
Yes,
That's
I
what I'm
understand.
trying to say that.
This is the description of what was going on in 2011.
Okay.
And why this is
It's not
important...
what's going on now.
No.
Okay.
Why it's important is that there was no secret here. The Venturas and their professionals went in front of the planning board, made a statement of use, and they also specified the square footage. Equipment storage, 2,800 feet. Temporary storage of construction equipment used at construction sites, 2,800. And then topsoil, mulch, compost, material storage, 56,639 square feet. So there was no secret about this. And if you look at the next page, you'll see this site plan in miniature. But more importantly, go to the last page of this exhibit.
But just before I move on, wait a
Yes.
second. I don't want to be here all night either, but it's saying storage of construction equipment, topsoil, mulch, compost, material storage. Years ago, I remember, they used to have in front of it, because it's right on Route 9, you can see as you drive by.
Yes.
And they used to have different shades or different types of mulch. They were in a square, railroad tied, am I correct?
And bins.
Railroad tied thing,
Right.
but they were selling different types of mulch. Okay. I didn't see high piles of rocks or stone at the time.
Okay,
It
well,
was just a mulch and a contractor shop.
and what year are you referring to?
What year? Well, let's see. What is this, 80s, 90s? I've been here a long time. Probably 20 years ago.
Okay, all right. Well, what's interesting is, at the time that they went to the planning board in 2011, they brought an as-built survey of the conditions, the topographic conditions, and it's certified by Bunny Associates, a land surveyor. And you'll see it's in your exhibit in miniature, but they show stockpile, the surveyor shows stockpile. There's no question that in 2011 and going back to 79 or 80, materials were being processed, screened, crushed, and stockpiled and resold. And it's shown right on the topographic survey by a licensed surveyor in 2011.
That's stockpiled areas, but it doesn't say what was stockpiled there, does it?
No, it just says stockpiles. The surveyor didn't identify the material. The surveyors wouldn't do that. Okay.
Well, the record doesn't show
It would have been
either.
nice if they did.
Well, you have photographs, a lot of
Not
photographs.
for next years.
Yeah, well, you do. You have
Okay,
photographs.
oh, okay.
Photographs that go back. Whoops. And
All right, okay. We'll go
if you
through
want
them.
to look at those, we could take a little turn. That's
What
number
what
14.
numbers are they?
I'm sorry. It's number 14, Exhibit 14. They're photographs that go back to 1996
Okay.
that show a crusher. The first photograph, Exhibit 14, the first photo itself, right out of the box, the one on the left, is a crusher.
I see it.
Okay, and that's 1996. And then you have photographs
Wait,
of,
how do I know that?
Yeah, there's,
There's no dates on this.
how do we know it's 1990?
you'll
What,
have.
am I gonna take your word?
No, don't take my word. I
Okay.
wasn't there in 1996. We're going to give you live testimony
Yeah,
that's going to
but
connect
you're
these
giving me,
photos.
showing me pictures, you're telling me from 1996, but they're not dated.
They
It
are
could be
dated.
from yesterday.
They are dated.
Where?
Right?
You wrote that down.
I did, yes, but you're going to hear.
That's not good for me.
I understand that. You're going to hear testimony connecting these
Oh,
photographs.
okay.
But you asked about proof, and
I
I thought
understand,
we.
but this, to me, this doesn't, I can't determine that these pictures are that date, 96, okay?
I'm just telling you
I'm gonna tell you what my consideration is, I can't
I
do that.
understand.
Okay.
You want us
Go
to
ahead.
connect the dots, and we're going to do that for you.
Sure.
But we go from 96 to 2000 and.
Four.
Well,
No, you got
2009,
2004.
and then 2013.
Right.
And then, the last four photographs are actually taken by the town code enforcement officer
Right,
in 2013 in connection with that criminal prosecution.
okay.
All right, but anyway, let me go back.
Can I just ask you a question?
Yes.
Where was this picture taken from? Looks like it's being taken from the air.
I believe that is an aerial photo.
It is from the air?
Yes,
Okay.
I believe so, yep. Okay.
But the pictures are not officially dated, so there's no way for me to tell a person. I'm just telling you my consideration, there's no way to tell a date.
That's a fair point. We're going to connect the dots for you.
Sure.
Okay, all right. So, July 18 of 2007, a notice of violation was issued to Ricky Ventura, by Code Administrator Tom Monroe, alleging essentially the same violations that have been claimed in the criminal prosecution and in the stop work order that's now before you on this appeal. That is non-compliance with an approved site plan. That's July 18, 2007. Go to Exhibit 25. Okay. Look what happens. Ricky receives the notice of violation. He speaks with Mr. Monroe, who directs him to submit an application to amend his site plan to update the industrial uses on the property. So Ricky has a new site plan application prepared. He submits it to the then acting code administrator, Robert Emmerich, who had taken over after Mr. Monroe retired. Mr. Emmerich advised Ricky that his outdoor storage of materials and rock crushing operations were pre-existing uses that were not in violation of the 1983 approved site plan, and therefore an amended site plan was not required. Now that's your code enforcement officer telling Ricky that he's not in violation of the 83 approved site plan, and accordingly Mr. Emmerich told Ricky that the then pending violations would be withdrawn from the court. And in fact, the violation was withdrawn by the code administrator on 7/27/09. So go to the second page. Of 26 it is. It's a letter or a memo from the code administrator dated
We're the same one, right?
26.
26 you're going now?
Yes, 26. It's right
Hold on.
before the 27 tab.
Okay, hold on a second.
Go to 27 and back up one page.
Hold on. Okay.
Okay? It's a letterhead of Town of Philipstown, Code Administrator, dated 7/27/09, addressed to the town court, Town of Philipstown Justice Department. Please remove Vicky Ventura per Robert Emmerich from court. All violations on file have been removed, and the building department is satisfied with this property. Okay?
Okay.
So, you know, it's like, I don't know if it's politics, I'm not that familiar with your town, but it seems like every few years, somebody pushes the code enforcement officer to go out and give Ricky a hard time, and when Ricky pushes back, they admit that there's non-conforming use here, that they're grandfathered rights here, and they withdraw the violation from the court, and the building department is satisfied with the property.
That didn't happen this time, though?
No, it didn't happen this time.
And explain to me,
Yes.
how did you lose in court if you have proof that this is, I don't understand how you could
Good
go all the way
question.
to the
All right.
state appeals court and lose.
I'm not being facetious. I didn't lose. I wasn't his attorney at the time. And I'll just tell you what any trial lawyer or any litigator would tell you, which is I would have tried that case differently. I'm not criticizing Ricky's attorneys at the time, but it's a case that should have been won.
But it wasn't.
Correct. And it's
Okay.
not binding on your board. Your board has the power to interpret the code and whether this is a non-conforming use. It's not up to a town judge to do
It's
that.
not binding, but it could be consideration.
I
So you
said-
gave it to
I-
us.
I
You
admitted,
gave it to
I
us to
admitted,
consider.
I admitted that last meeting.
Okay.
It's something you can consider. But if you're going to rely solely on that, I think I
didn't say
win
that.
on
I just said
appeal.
It's something that could be considered.
I agree with you, Mr. Chairman. Absolutely. All right. So, since that violation was withdrawn and the code enforcement officer in 2009 said all is good on the site, the outdoor processing, screening, crushing, stockpiling continued on the property up till tonight. Okay? So, let's go to Exhibit 6B. Okay? I want to talk about,
So are
Yes.
they currently crushing and,
well, we have a stop work order, so we're not processing. So the piles are getting higher because we can't process.
okay, so you're not crushing right now?
No, no. So don't hold it against us that the piles are higher.
Piles are getting higher. You mean people just coming in and dumping off stuff? Is that what you're saying?
The stop work order goes to processing. It doesn't go to receiving materials. We'll get into that in a minute, okay?
Sure.
All right. So let's go to the code section, and I have a blow-up. This is the 1968 code, which was in effect at the time. And the code had a Schedule A of permitted uses, and I've blown up page 5 of 6, because that's the one that's really in play here.
How'd you know that?
Permitted use number 36. Establishments for the manufacture, processing, or assembling of goods when occupying not more than 10,000 square feet of floor area. And if you look under I, the District Code I, it's a permitted use under the 68 code. Item 37, establishments for the manufacture, processing, or assembling of goods without the limitations of line 36, meaning the 10,000 square foot floor area. And again, it has an S, it's permitted use. Now, 39 is the one that probably draws the most attention here. Warehousing and wholesale businesses, building contractors' yards and garages. There it is, contractors' yards and garages. Not defined anywhere, but there it is as a permitted use. Lumber and building material yards and storage, blah, blah, blah. Okay, and then 46 is very important too, that you're going to have to interpret, which is all accessory uses customary with and incidental to the aforesaid permitted use. So those were the uses that were...
One question for me.
Yes.
I understand it says manufacturing, processing, assembling of goods and so on. I don't see where it says rock crushing or soil.
I haven't seen
Can you show me that?
Right here, accessory uses customary and incidental to the aforementioned permitted uses. If you're allowed to process goods, that's an accessory
You're saying
use.
rocks or goods, is that what you're saying?
Yes, absolutely.
Okay.
Okay, and I'll get to the definitional section of goods.
Says that?
Yes.
That, an actual legal document that says processing means
Your
crushing
code.
rock.
Your code.
Okay.
Okay, all right. So there's no question that in 1968, the outdoor processing of goods were permitted in industrial districts, and this was an industrial district.
Well, you said, wait a minute, you're saying no question, okay?
Right.
I don't see it in there. That's why I'm confused here.
Yeah, fair enough. Here we are. This is the 68 code again.
Where is that? Under what page? What is number is
Okay,
that
it's
under?
page 17. It's 6C.
6C?
6C. I've got a blow up on it.
Okay.
All right?
We can't
Yeah,
see
we're
that
going
blow
to
up.
read it. We're gonna
Yeah,
read it. Go
okay.
ahead.
So 24.7, outside storage. Outside storage, including storage and display of merchandise, supplies, machinery, other materials, and the outside manufacture, processing, or assembling of goods, and we'll come back to what goods are. Excluding areas for parking of registered motor vehicles shall be limited as follows, blah, blah, blah. Outdoor storage and processing is permitted right there. And you drop down to 24.7.2, industrial districts, that's our district. And it says, in industrial districts, outside storage areas shall not extend, blah, 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 blah. The fact that they put restrictions on it means that it's permitted. It's implicit in section 24.7 and subsection 24.7.2. So there's no question that not only is outside storage of materials and goods, but outside processing of goods is permitted as well under the 68.
Yeah, but I'm saying, you're saying
under the 68 code.
I understand what you're saying.
Okay.
And I could
All right.
read it here. You're saying processing or assembling of goods.
Correct. Now, let me just go to that.
Wait a minute, I just have a hard time reading that as rock crushing and soil
Yeah, I agree.
processing, you understand what I'm saying?
Okay.
You know.
All right. So we've already touched on the fact that contractor's yard and garage is not defined anywhere, separate
Correct.
from the listing here. It's right there in ink, black
Right.
ink, but it's not defined. The word goods is also not defined in the 68 code. But if you look at Merriam-Webster dictionary, it defines goods as A, something that has economic utility or satisfies an economic want, or B, something manufactured or produced for sale. Crushed rock is a good. Or you can go to Collins English Dictionary, define goods simply as things that are made to be sold. So the fact that the ordinance wasn't more tightly written is not the Ventura's property, it's the town prosecution's
So you're
property.
saying that anything that's not public, completely excluded, you can do? That is not officially written into the code that you can't do, you can do?
I'm saying that as contractor's yard was then understood in
I haven't seen a definition.
1968. No,
We have no definition of contractor's yard. We agree on that, right? There is no definition
Yeah.
of a contractor's yard.
correct,
Okay.
or of goods.
Or
But
of goods. Okay.
zoning ordinances necessarily restrict the use of one's property. Historically, our property rights were notably free of government intervention prior to the enactment of zoning regulations. In fact, the major impact of zoning regulations are on our property rights, which are afforded the highest degree of protection under the common law we inherited from Great Britain and under our Bill of Rights and the federal Constitution and under New York State's Constitution. Hence, government regulations, zoning regulations, that infringe on our rights to our own property are subjected to what the courts call strict construction. And our Court of Appeals in Albany, the highest court, ruled long ago that zoning regulations being, it's a fancy legal term, derogation of the common law, must be strictly construed against the government body or official that adopts the resolution or adopts the restrictions or tries to enforce them. That's the 440 East 102nd. I don't want to cite a lot of law here, but the law in New York has firmly established that zoning regulations must be strictly construed against the government body or against the government official trying to impose limits on our property rights.
So what's to stop them from, say, processing toxic waste?
The DEC, for one, and I'll get to that.
Well, the point that I'm trying to make, that's not mentioned in the code either. You says process, it says process soil and construction debris.
I understand what you're
extending. You're extending it to a point that, in my opinion, is rather absurd.
We're not taking a position that we have the right to process toxic materials.
No, I'm not saying that you are,
Right.
but you're extending past what I think is reasonable.
All right, but so what does the strict construction mean under New York law? It means several important things. First, if there's an ambiguity or doubt with respect to the interpretation of a zoning ordinance, it must be resolved against the government body or official.
Was that brought up in the lawsuit that you've gone through?
It wasn't a lawsuit, it was a criminal prosecution. And again, I didn't try that case, so.
So you don't know, is what you're saying?
I don't know. I don't. But the judge didn't rule on that issue. I know that because I read the decisions. Second, zoning regulations cannot be extended, like you are asking about, by implication, beyond the strict wording of the particular ordinance as written by the government body that's trying to impose restrictions on our property rights. So you can't take a word and extend it in favor of the government. That's not the way the law works in New York.
But you're taking the word and extending it in favor of the applicant.
Because that's the law in New York. Any ambiguity gets resolved in favor of the property owner because, like our Second Amendment rights to bear arms, we have rights to possess our own property and use it as we please, subject to reasonable zoning. But if the government's going to try to restrict our rights to our property, they have to be specific. They have to be clear. There cannot be ambiguity about it. And here, they don't define contractor's yard, and they give us the broad accessory use clause under 46.
But they never talk about crushing rock as an accessory use. And processing of goods, in my opinion, does not translate into crushing of rock.
Then why did the planning board say you're good to go? Why did the code enforcement why did the code enforcement officer withdraw the violation and say everything's good out at the site?
A lot of things you're stating here came from the planning board.
Some from the planning board, mostly from the code enforcement administrator.
We're neither. But go ahead.
All right. The last thing, the strict compliance, and I'll move on. It means that although a determination by your board on a variance is afforded great deference by the courts, because they're not going to second guess you, you hear the evidence, you hear the testimony, you weigh it, you balance the 5 factors, et cetera. When it comes to a strict interpretation of a code, if you get it wrong, a court's not going to just defer to you because you're good people that volunteer your time. The court's going to interpret the code for themselves. So it's a different standard. Now, I'm not implying that you're going to get it wrong. I just want you to understand, in a variance, a court will protect your backs unless you really, ignore facts. When it comes to a code interpretation, it's a matter of law, and the courts are not as deferential. So with these rules of interpretation of mine, let's look at the actual sections and amendments. Now, when Mr. Ventura, Elder Mr. Ventura, first
What are we looking at now? Which item?
I'll tell you in a second. When he first acquired the property in '79, the premises was within the industrial district, and it was under the '68 code, which permitted the processing of concrete and asphalt of goods made from concrete or asphalt in industrial districts. Likewise, the '68 code allowed the outdoor processing of dirt, soil, gravel, and/or rock, and rock crushing as permitted principal use or accessory use, which is customary and incidental with the processing of C&D and land clearing materials. So Section 23.2 of the 68 code, which is section 6A. Go to 6A. And I appreciate your patience. I
No,
know
no,
this
this
isn't-
is
I know
important.
this
It's
isn't the
important.
most
It's the gentleman's livelihood. I'm not here to,
All right.
you know,
All right,
but I just want, if I have questions, I'm going to ask.
Absolutely.
Okay.
I appreciate that you're,
But wait a minute, you said that it was permitted by the
right.
1968 code, but it's,
I'm gonna,
that's an interpretation.
no, I'm gonna prove to you that it was.
Okay.
And that the
Okay.
town believed it was. Okay?
Sure.
Just bear with me. We're getting there. Under Section 23 permitted uses, this is 6A, I'm sorry, yeah, 6A. Section 23.1, Schedule A, this is the Schedule A. Permitted uses is hereby declared to be a part of this local law. Land, buildings, or other structures in a district may be used for one or more of the uses and no other specified in Schedule A. So if it's in Schedule A, it's permitted. Drop down to 23.2, prohibited uses. Any use not specified in Schedule A as permitted is prohibited, okay? And to further assist in the interpretation of Schedule A, the following uses, the listing of which is not intended to be exhaustive, are specifically prohibited. Your town board back in '68 thought of two things they didn't want any ambiguity about. They said, the use and occupancy of your trailer as a dwelling, no good, prohibited. Or two, trailer parks, didn't want any part of those things. They could have, but they didn't, said, we don't want rock crushing in industrial districts. They didn't say that. They could have said, we don't want soil screening in an industrial district. Didn't say that. They could have said, we don't want to have concrete and macadam from road projects or driveway projects to be processed and crushed and reused as item 4. They could have said that. We don't want that in an industrial zone. They didn't. Now, I'm going to get to your question. Why is it that the uses that have been going on since '79 are in that Schedule A of permitted uses? And the, okay. We talked about the goods were not defined, right? Okay. All right. So if any board member should have even the slightest doubt whether the outdoor processing of goods made from concrete or asphalt, or the processing of dirt, soil, gravel, and/or rock crushing, if you have any doubt whether that was permitted under the '68 code during the 37-year period between 1968 and 2005, you need only look at the legislative action taken by your own town board. And that the final action was August 4th of 2005. Go to Exhibit 9 now. Okay, so in 2005, and the first, we'll go page by page here because this is critical. This is the guts of the whole matter. April 28, 2006, the then town attorney, Edward Doyle, writes a memo to the supervisor and town board concerning, or read, local law to amend zoning law, chapter 175, Schedule A. And this is him writing to his town board. You have asked that I draft a proposed local law to amend the zoning code to exclude the manufacture of concrete or asphalt or goods made from the same, or the processing of soil or rock from Schedule A, lines 36, 37, and 39. Enclosed, please find a proposed local law to accomplish this, to exclude those uses from 36, 37, and 39. And to proceed, he advises, the town attorney advises the town board and the supervisor that you request Tim Miller, who was the planner, to prepare an environmental assessment form, which he did. And after doing the foregoing, you may schedule a public hearing on the local law. All right? So, the town attorney drafts a local law, and look what he does. Go to the next page, and I have a blow-up. He takes these very same 36, 37, and 39, and he adds the howevers, which I call the however paragraphs. So 36, establishments for the manufacture, processing, or assembly of goods were occupying not more than 10,000 square feet of floor area. That's the law since 1968. However, this is the new law. This is the change of the law. This is an effort to prohibit the Ventura property from doing what it had been doing since 1979. And the first, however, such establishments for the manufacture of concrete or asphalt or the manufacture, processing, or assembling of goods made from concrete or asphalt are prohibited. The processing of dirt, soil, gravel, and/or rock crushing is prohibited. Now, Ms. Claire, if the town board and the town attorney didn't think that 36, 37, and 39 allowed the processing of soil and dirt and vegetative matter and the crushing of rock, why take those same categories and then add the however clauses in 2005? Why? Because they were changing the law. And when they changed the law, bingo, he's non-conforming. The town threw him into non-conforming. The town grandfathered him in. And the second, however, is identical on 37. However, such establishments for the manufacture of concrete or asphalt or the manufacture, processing, or assembling of goods made from concrete or asphalt are prohibited. The processing of dirt, soil, gravel, and/or rock crushing is prohibited. How much more evidence do you need that the town attorney and the town board believed that these, since 1968, these three scheduled permitted uses were broadly enough written that it made them legal and had to be made illegal? And that's what they did in 2005, and that's why you have to find that he has been grandfathered.
How do you know it's not directed at the other rock crushing facilities we have?
It may very well be. It doesn't have to be just directed at him.
That it was specifically
I don't know
pointed
that.
at the Venturas.
I don't
That's
know.
what you're saying.
No, I don't know that it was specifically only the Venturas that were targeted.
Oh, but you said that, though.
Well, I said it's changing the law as exactly as to what they were doing on their property. There may have been other people that also were thrown into nonconformity.
So how do you know it's specifically them and not the other rock crashing?
Mr.
You still
Sestone.
haven't proved that.
Mr. Sestone, it doesn't have to be targeted at him. The
No,
fact
but
is,
you're saying the town did it. You've said it more than once.
I didn't
Specifically, it was guided at the Venturas.
I did not
And
say,
that's not
I
true.
didn't say it was targeted at the Venturas. If you misunderstood me, I
I
apologize.
heard the same thing.
You heard the same thing I did.
Let me be clear then, because I don't want you distracted. This is critical. I'm not claiming that the town board targeted the Venturas. They didn't have to target them. They changed the law under 36, 37, and 39, and that grandfathered the Venturas. Maybe somebody up or down Route 9 also got grandfathered. I don't know. It doesn't matter. It's irrelevant. The fact is they were doing it at the time.
Where you made the accusation.
Mr. Sestone, I didn't accuse anybody of anything. And I don't know why you're harping on this,
Nothing from
Mr.
the audience,
Sestone.
please.
I don't think it's fair.
Also,
At this
I mean,
time.
it's possible that the town was clarifying what was meant in the original law. I mean, and.
Well, let me ask you a
Do
question.
you think that's a
I understand-
reasonable interpretation of the action they took? Let me keep going.
I think it's
Oh, wait.
I don't want
Let's,
you to have
before
any
we
doubt
keep
about
going,
that.
let me ask you a question.
Yes.
The zoning codes are changed all the time. You know, the town meets and they vote on different
Yeah.
laws and so on and so forth.
Right.
Okay, I purchased a piece of property, and years ago, it was like a 10-foot sideline. Then it went to 20 feet. Then it went to 30 feet sideline. I built a house. I had to conform to that 30-foot sideline. I wasn't grandfathered in. So,
Well, I wish you had hired me.
hire you. Probably couldn't afford you. But, you know what I'm trying to say? But we do a lot of people this time, they go before.
With all due
and
respect,
not
Mr.
bothered.
Mr.
So you're
Chairman.
saying, all right, so you're saying everything,
It's a little bit apples and oranges, your example. But what I'm saying is, and getting back to Ms. Claire, if you look at the EAF, the Environmental Assessment Form that the town planner, Tim Miller, filled out, look at the description.
Where is that?
Look at the description. It's part of 9.
Part of 9?
Yeah, it's about 4 or 5 pages into 9.
Okay.
This is the town's own planner, and he describes what this legislation's intended to do. And I'm quoting him. Adoption of amendments to Chapter 175, Schedule A, zoning law permitted uses of town code. Proposed amendments would exclude the manufacture of concrete or asphalt or goods made from the same or the processing of soil or rock from Schedule A, categories 36, 37, 39.
That's right.
Ms. Claire, he doesn't say to clarify, he doesn't say so there'll be no doubt. He says to exclude. He's changing the law. Okay, keep going. Let's turn.
Okay,
Which,
well, so why do you think that the town would do that? Do you think?
Because they didn't want, I'll get to that.
Well, why do you think so?
all right, what page are we on now?
I mean, is it a health issue, you know? Is that what it is?
Well, I don't know, because the legislative history doesn't say what their reason for prohibiting what had been going on for many years. But if you keep going, you'll see a planning board letter dated May 19, 2005, concerning this, because whenever the town board wants to amend the code, it has to circulate it to the planning board, maybe to your board. I don't know what your town code says about that. And the planning board reviewed the proposed amendment to exclude, and this is the planning board chairman, to exclude the manufacture of concrete or asphalt or goods made from same, processing of soil or rock from Schedule A, lines 36, 37, and 39. The planning board is in agreement with this proposed law. Okay? Planning chairman doesn't say it's good to clarify it because there may be some ambiguity or may doubt. They don't talk about that. All right, now we get to the town board, and this may give us some insight as to what they were thinking. It's a public hearing on the amendment, July 20th, 2005.
Is this in 9 also?
This is in 9. Keep going. It's a public hearing. It's this is what it looks like.
I got it.
You got it?
Got it?
I don't have it yet.
Keep going.
You may have gone too far, Mr. Dick.
Too far.
This
Look
here?
for yellow.
Okay,
No, that's not it either.
that's not it either.
Yeah, you can
Okay.
come with me if you want.
Resolution?
No, it's the public
Schedule
hearing.
A. It says
And
Schedule A.
and I'm reading. The Philipstown Town Board held a public hearing on the above date at 7:30 at Town Hall. The purpose of the hearing was to hear comments for or against a local law to amend the code of the Town of Philipstown, Chapter 175, to change Schedule A, permitted uses, and drop down. Town Attorney Doyle, he's the guy that drafted this, explained that the proposed amendment would amend lines 36, 37, and 39 of Schedule A, the permitted uses in Schedule A in the zoning code. It provides that establishments for the manufacture of concrete or asphalt and the manufacture, processing, or assembling of goods made from concrete or asphalt are prohibited. The processing of dirt, soil, gravel, and/or rock crushing is prohibited. And then Councilman Shea, who I believe is your current supervisor, commented that he thinks this is a favorable addition to the code, noting that it will lessen the impact on Route 9. Nobody says that this is to clarify some ambiguity. Nobody says that this is so there be no doubt. This is clearly a change in the law from what existed since 1968. And then go to the actual resolution itself. August 4, 2005. This is adopted by, it was presented by Councilman Shea, seconded by Councilman Hosner, and unanimously carried. And it states the purpose, I'm quoting, the town board has determined that certain uses should be prohibited within the town. Not clarified, not avoidance of doubt, prohibited within the town, either because there are already a sufficient number of such uses and an additional number would be excessive, or because the introduction of such uses would have an adverse impact excessively disproportionate to the corresponding benefit thereof, and they adopt the howevers. 1, 2, 3, boom, boom, boom. And that becomes the new law of under the 68 code. And that's the last resolution as part of 9 is the actual resolution that was filed with the Secretary of State in Albany. In my mind, there can be no question what happened in 2005. They changed the law. They made prohibited those activities that the Ventura family had been doing on their site since 1979, prohibited. And by doing so, they granted them grandfather status, legal non-conforming pre-existing status. So let's go to your code that talks about what happens when there's a change in the law, the zoning law.
Where
Section
was
175-23.
What exhibit here?
Where is
Oh,
that?
okay, yeah,
Yeah.
fair enough. I gave
I'm
you.
trying to
that.
keep up with you here.
No, that's good, because I gave that to you. It's Exhibit 13.
Before we get there, just to clarify, and you have to forgive me, Michael, because I don't have the packet. I don't know if you have
Sorry,
an
I
extra
killed
one.
enough trees just doing these. I should have made
And
another
I
one.
appreciate that, but
Yeah.
I just wanted to see if I missed something,
All right.
because you indicated, I believe in February of 2011, your client sought amended site plan approval
Right.
from the planning board to amend the 1983 site plan.
Right,
So there was an application to do that.
correct, and they went before the board once, and then the
And
board.
what happened?
A good question, Adam. The board scheduled the site walk, and then it went quiet. And what I suspect, and I was going to get to this in a minute, is that in 2011, the town scrapped the 68 code completely and adopted the new code. And I think the planning board may have put this on hold to see what the new zoning, and I'll get into that a little more detail on what happened in 2011, but I suspect it had something to do with that. But
But there's an application, but no determination by the planning board.
correct.
To date.
That's correct.
To date.
To date, they
Okay.
paid the fees, $900. They paid $5,000 into an escrow, and I think all the board did, the planning board did, was to maybe do a site walk, and I'm not even sure that happened. But it was never added back to their agenda, and I'm only guessing, I'm surmising, that maybe it had something to do with that in 2011, a complete new zoning code was being reviewed following a comprehensive plan revision. I don't know exactly why it went silent, but the planning board didn't take any further action on that. I don't know if Ricky can help me any more detail on that.
They said that the plans disappeared. They couldn't locate, they couldn't find them.
Okay.
Then I found them inside our file a couple of months ago.
Okay. All right, so what happens, because in 2005 they prohibited, with the famous however clauses, the uses. This triggers the non-conforming use provisions of Chapter 175. The purpose of this Article 6 is to establish rules that apply to uses and structures initiated legally, that's us, under previous land use regulations, but no longer comply with this Chapter 175 zoning as it has been amended. There are three types of nonconformity, as you know. There's nonconforming uses, that's the one we have before you, nonconforming structures, nonconforming lots. So I'll drop down to nonconforming uses are legally permitted to be maintained in accordance with the provisions of this chapter. And so we get to nonconforming use. Any use lawfully existing at the time of the adoption or amendment of this chapter, or of any preceding zoning law or ordinance, the 68 ordinance, the 2005 amendments to the 68 ordinance. I continue. Where such use has continued but is not now permitted by or does not conform to the use regulations of this chapter for the district in which it is located. And then subsection 175-23A states continuation. And it makes as clear as a bell, any use, any building or other structure, or any lot which existed lawfully, including by variance, on the effective date of this chapter. And by the way, the effective date of this chapter, I believe, is May 5th, 2011. On the effective date of this chapter or any amendment thereof, and which fails to conform to one or more of the provisions of this chapter, or such amendment thereto may be continued, subject to the provisions limitations herein specified. Any business owner or tenant may continue to operate an existing business. That's your code. Any business owner or tenant may continue to operate an existing business, or any business in the same use category as the existing business in the zone where it is not permitted by this chapter, and may sell or transfer it to another owner or tenant who shall be permitted to operate the same business or any business in the same use category as the existing business in the future. That's about the broadest nonconforming use language I've seen in any code. in Westchester, Putnam, or Dutchess. And I've been doing this for 40 years. It's a very generous non-conforming grandfathering clause. And we need the benefit of that. And I believe we've proven our entitlement to the benefit of that. Now, in 2011, they scrapped the code. They adopt a entirely new zoning code. And they have a public hearing. And go to Exhibit 12. We're winding down here. I'm getting close. On Exhibit 12 is a transcript of the public hearing on the new zoning law for the town of Philipstown. It was conducted February 9th, 2011 at Haldane Central School in Cold Spring. Okay? Page 71. Some residents were asking, well, what happens to my non-conforming, to my business or my yard or whatever it is? And Supervisor Shea addresses the public hearing and says, thank you. And I'm reading his words, your town supervisor. The one thing I would like to make clear is that on Route 9, if you own a business currently, you can continue that business. Do any of you sitting here have any doubt that the Venturas owned a business on Route 9 on February 9th, 2011? I continue Supervisor Shea's words. You can sell it as that business going forward. There have also been some expansion of business rights on Route 9. There are also provisions for expanding a pre-existing non-conforming use that are more generous than we have in the current zoning. Chairman D, that's when I was talking earlier about expansion is not necessarily a crime. Okay? Drop down to Supervisor Shea's last comment. However, he's asking a rhetorical question. How is it going to impact every single business on Route 9? And this is your supervisor's words. Every single business on 9. I can say this, that exists today will exist after this zoning is adopted in the exact same form as it exists, as is. That's your town supervisor. He's given the broad non-conforming status of your code some of his own thoughts and comments. The 2011 code rezones this from industrial, it's no longer industrial, now it's HC. And of course, HC is, the purpose of the HC district is to allow commercial uses that rely heavily on automobile and truck access, and that would not be compatible with a hamlet mixed-use area. This is exactly the site for that kind of work, for that kind of truck traffic, okay? So the fact that it was not only 2005, they prohibited for the first time ever since 1968, with the however amendments, they prohibited what the Venturas were doing. In 2011, when they rezoned this highway commercial, they further cast this into nonconformity. And currently in an HC district, outdoor processing, screening, crushing, and stockpiling of C&D and land clearing materials is not allowed under the current code. But they're grandfathered, and they're protected by the Constitution of the United States and the state of New York. Now, I've shown you the photographs, and we're going to tie them down and get them dated for you at the next meeting. There are equipment leases, and I told you earlier that they would, when they had enough materials on site, they would rent a machine, a piece of machinery. You have all that, and some purchase invoices. Here's something really fun, Exhibit 16. One of our customers, back in June of 2009, well before the 2011 amendments, was the Philipstown Highway Department tipping fee for 12 loads of 12 yards each, 180 yards at $2, $360. And the next page is a check issued from the Town of Philipstown to Ricky's company. So one of our customers that was using our site for recycling was your very own Town of Philipstown. Again, it's fun, but it's really informative because we're not doing something secret out there.
Purchase fill?
No, they brought material into the site and dumped it.
Oh, okay.
That's what a tipping fee is. They tipped the back of their truck, dumped what was in there.
Oh, I see.
And incurred a $360 expense for the taxpayers. So, and it's fun, I put it in there because it's funny, but also it proves that we were never hiding anything. August Ventura was an immigrant from Portugal, straight shooter, hardworking, salt-of-the-earth guy. He was doing this in '79. His sons have inherited the property, and despite some really serious health issues for Ricky, including a heart transplant, he's trying to make a life out of this town and out of this property and do the right thing. You have affidavits, which I really need you to study carefully. There's 8 of them, including Ricky's.
They're in here.
They're in here.
But what?
What numbers?
Well, you can
They're-
study that
I think
later.
there's 17 through, I'm sorry,
Right.
18 through 25.
Okay.
We do it in our spare time.
24. You have time for that. Now, lastly, I'm going to finish up with this.
Sure.
The New York State Department of Environmental Conservation, the DEC, you're all familiar with that. It's a state agency. The DEC has jurisdiction over the transportation, storage, treatment, and disposal of solid waste under Article 27 of the Environmental Conservation Law. We call it the ECL. And under Title NYCRR Title 6, Part 360. The DEC also has jurisdiction over material recovery facilities under New York State CRR Title 6, Part 361. The Ventura property's ongoing processing and stockpiling and rock crushing, Mr. Sestone, of materials is approved and regulated by the state of New York, by the DEC. This is a C&D processing facility. It's approved, it's permitted, it's registered by the DEC. It's been given a facility ID number, and look it up, number 40W06, and the permittee, the licensee is Ricky's company, RNV Green Processing and Supply Corp. Go to Exhibit 27. You have 3 documents that are from the New York State DEC that basically certify that this is in fact a C&D processing facility, and it's registered by the DEC. And as part of New York State regulations and oversight by the DEC, the DEC performs periodic inspections of the Ventura property, and they periodically review records that are required to be maintained at the property as to what material's coming in, and more importantly, where is it coming from, so that we don't have contaminated materials, Mr. Sestone. We know we don't. We don't accept contaminated materials. Pursuant to this, our DEC registration, the Ventura property is permitted by the state of New York to receive and process uncontaminated concrete and other masonry waste, asphalt, pavement, brick, soil, and rock. And the DEC, as I said, registrant is Ricky's Corporation, which was formed back in August 5th of 2011, and it continues to operate this DEC-approved C&D processing facility to this day. So I've said a lot, I've thrown a lot at you, I've given you a voluminous record. I'm happy to answer any questions. I have some live witnesses if you have any energy left, or we could put this over to next month.
Well, I'm going to put it over to next month, but what time is it now? 9:30. I think you'd have to agree I've given you ample time.
You've been most kind, and their questions have been
And we
excellent.
do have the
Excellent.
affidavits from the witnesses or so on and so forth that we could read.
Yeah, I wouldn't put on the same person that gave an affidavit, but we may have next month.
Oh, well, yeah,
Next
we can
month,
do
we
it
may
next
have,
month. We can do it.
particularly with respect to the photographic evidence.
And the photograph, you can get some kind of date, proof, because this time is not no value to me. Is there anybody here in the audience other than from Mr. Ventura who would like to speak? Anybody, neighbors? Yes, sir. Ring the bell, please. The gentleman's going to speak here.
Yeah, if any of you would like to hear tonight from our engineer about this, what goes on there and what the DEC overview is, he's here.
Okay. Give us your name, sir, please.
My name is Wayne Stevens, and I live on 33 Langate Road. I'm Ricky's neighbor,
Okay.
his direct neighbor. Hey, listening to this gentleman, it seems that this is a legal matter right now. But what I would like to bring to light is that although the gentleman says that there were specific times of days that the hours of the weekdays that this facility will be used, there will be deliveries there at 5:45 a.m., 6 a.m., 6:15 a.m., 8:15 at night a.m. And you can imagine the noise that takes place when you have a back-end dumpster or what have you, unloading and slamming back, and then the machines just pick up and start moving that material right away. Now, if something
Machines
is...
are there working at that time?
Excuse me?
The machines are there, what?
Yeah, just to move the debris out of the way.
Okay.
5 a.m., 5:30?
5:45 a.m.
Okay.
I have, and I think what is concerning to me as well is that if at one time they went to the planning board to get a entrance on Route 9, I think that if it is in their favor, that those goes to Mr. Ventura's favor, that I think something will have to be done with that. Because if you go down Lane Gate, I have a couple pictures that I took.
Sure.
That I feel is gonna be a problem for buses or people coming out of Lane Gate Road.
What's going to be the problem? The entrance you're talking about? Or?
Yeah, the entrance on Lane Gate Road.
Okay.
Oh,
Oh, so you would like to see the entrance changed? Is that what you're
Yes.
saying? Okay.
Yes.
All right.
And you can see, they have people just back up onto the road. I can
Right.
do one, two, if you like.
That's a truck waiting to unload, I guess, that's what that is?
Anything we can do to make your life better, we will do that.
Oh, we look at different pictures.
A couple times when I was coming out of Lane Gate Road onto Route 9,
Okay.
and I know that Mr. Ventura cannot control the truckers. You know, he can request that they abide by rules, but the truckers are going to do what they want.
Well, you could open up at a certain time.
Right, right. Right.
Right.
And I think, a couple of them have just pulled right out of his yard without looking either way. I had to slam on my brakes one time to not hit somebody. And when you're on Route 9 and they're backing up into his facility, there's no line of sight for that trucker to see anybody coming down Lane Gate Road. And at times you could see these pictures, they would just come across and you would have to stop. And on occasion, they would drop debris onto the road. And my fear is that somebody coming down the road would hit one of those and just end up right in oncoming traffic. Okay, that's some of my main concerns. I think another concern I have is I had an appraisal done on my property a couple months back, and it expressly lists the facility as being detrimental to the property and the property owners and my neighbors.
Can you give us copies, provide us copies of that?
I'm not sure if I want to share this.
Oh, okay,
Okay?
sure.
I don't mean, certainly you're free to speak, but I think the board is, the concern, the appeal is the legality
Yeah.
of the predicate
Yes.
use as opposed to generalized complaints about the use that's there. I mean,
Okay.
the board, it's their prerogative to listen to those issues if they so choose, but I just wanted to, comment that the predicate issue is an appeal from a stop work order on the basis that this is an
I think
unauthorized
I did make that
use and
statement
without site
when
plan
I first started
approval.
talking, that I realized this is a legal
No, we understand
issue
your
right
concern.
now.
We're-
But,
we're
I'm
certainly,
Ricky's neighbor. This is not an indictment against Ricky. We have a cordial relationship, and I understand it's a man coming here to fight for his rights to do what he wants on his property.
Well, you're entitled to your...
Exactly.
You're entitled to what you have to say.
It's,
so.
it's,
Wayne, you're not worried about the toxic plant landfill in your
sure I
backyard?
am, sure I am.
You don't think
Okay,
that-
okay,
Sure,
Mr.
okay,
Ventura,
sure I do.
please, let's not, this is not going to turn into relax, take it easy. Not going to turn into a brawl here. We're going to have, next month, you're going to have a chance to talk. I gave your attorney ample time to present his case, so let's give this gentleman a few minutes, please.
I just want to show, when you talk about having, you'll be able to see it. Okay. Now, since the amount of debris has been leveled so high and brought closer and closer to, I guess, the driveway of Mr. Ventura, this was actually a Saturday morning that they're just out there moving the debris around. And you can imagine, as a homeowner, my quality of life
And there's been plenty of occasions when there's rock crushing going on and things of that nature where I just leave my house because it gets to the point where you just can't handle it anymore. Okay? And this is within earshot, eye shot from here to that window of my front door and my windows. Okay? Now, I understand the gentleman has, go ahead.
How long have you resided at 33 Langate Road?
Since 2002.
Okay.
Now, when I first originally moved here, I had gone to the town before I purchased the property, and I believe the gentleman's name was Tom, and I asked him what was allowed in the facility, the landfill, and also Mr. Ventura's property, because at the time, my property and the two properties were zoned differently, industrial. And I did know that Rick did do some soil processing. He had the small machines that he would do, the machines just processing soil. It was never to the extent that it is now. It's, rock crushing and the like. And I understand this gentleman is defending his rights, but it's on a scale now that when I first moved there and inquired about it, it was nowhere near what's going on now. And when it comes to doing 3 or 4 days every 3 or 4 months, that's a lot different than every day for 24/7 when you're living in an area like that.
Right.
It's totally different.
I don't know what the time restriction is, so I'll have to check into that before the next meeting. I don't know what his time, if his hours are that he could do it. I'm sure there's got to be a time. I don't think it's 5:45 a.m. I would have to say that, but I will find out what the time is.
Yeah, I think when I tried to inquire several times, and we had gone through a couple building inspectors and Mr. Shea, they did respond to me, but I think because this is an illegal issue, I could never really get a direct answer on what's going on.
Right. Well, there's got to be a time you can do business. I
Yeah.
mean, we'll find out what that
Okay.
is. Okay.
Okay.
This is off topic, but you took Ricky to court because his dog was barking, and they were gonna put his dog to sleep.
I don't know if you were there,
All right, well, let's.
but I'd like to address that.
Wait. She can speak next, okay? It's one person at a time. We're not going to get into, arguing back and forth, okay? Finish what you have to say, please, sir.
I went and I spoke
No, speak
right
to me.
there
Speak to us.
to address.
Forget about it.
Okay.
Speak to us.
Okay. Really, where we're at right now is quality of life for me and my neighbors. And I understand that Mr. Ventura he needs to make money and he needs to do his work. But there is a quality of life issue for the neighbors and our property values as well.
Okay.
And when I first moved there, it was not at the scale that it's at now. And 24/7, or the hours it's operating, is certainly, in my opinion, not within the code.
Okay, thank you very much. Is there anybody else, one second, is there anybody else who lives in the area or something like that at this point in time would like to speak? Yes, you step up to the mic, please.
Denise Grillo, 28.
Yeah, I know, you got a
I know.
step stool.
I know.
That's okay.
It's okay, I'll stand on my toes. Again, I can't really speak to the legal issue, but I can confirm what Wayne is saying.
Give us
that
your name, please.
Denise Grillo,
And you live where?
28 Lane Gate.
Okay.
How long have you lived there?
We've lived there about 15 years. When we first moved in, it wasn't noisy the way it is now. The noise starts at 6 o'clock in the morning. It goes well into the evening, and it happens on weekends as well. So I want you to know that the quality of life has been seriously compromised. That's all I have to say.
Okay, thank you.
Thank you.
Anybody who spoke, can you do me a favor, just before you leave, print your name and your address back there's a form back there at the table. Put your name and your address so we know who spoke, okay. Now, young lady, would you like to say something, or? No, okay.
We take a break.
Just very briefly, if we are able to, through your deliberations, confirm that we have legal non-conforming status, we're going to go back to the planning board. We're going to get an amended site plan. We're going to try to have a new opening on Route 9. We're going to have a fully enclosed building so that all of these processing activities are going to be inside a building, state-of-the-art, with how many thick inches of cement floor, and it's going to have capture of all materials and liquids, and everything's going to be inside. And it's going to be a great improvement to the neighborhood. It's going to provide a public service for recycling. Isn't that what everybody's focused on today is recycling materials, and we're going to do it inside. And so,
You're going to take all that stuff and put it inside the
and-
building?
Yes. Well, no, the
It's gotta be a big
processing.
building.
No, the processing.
Oh, okay.
The crushing, the screening, all of that's going to be done inside.
Okay.
And by the way, our 83 approved site plan doesn't impose hours of, no, but that doesn't.
Doesn't
that-
have hours.
It doesn't have hours specified.
Okay.
But there is, you do have a noise ordinance.
Right.
But frankly, we're not good neighbors if we're allowing people to
No, not at that time of the
activity
morning,
at 6 in the
and no,
morning.
of
And
course.
we're going to get that straightened out.
Okay.
But we need you to make the ruling, and then we're off to the planning board to make this a state-of-the-art facility, fully enclosed.
Okay. You've given us a great deal of, to look at here, okay? And well, I've given us time to look at it. And you're going to present us with that other court case. We're going to meet next October 7th, and hold the public hearing open, okay? And at that point in time, if anybody wants to speak, I don't want to cut your witnesses short or anything else like that, but we will be able to read their affidavits and get an idea of what they're trying to say, okay?
I think you've heard from two neighbors who I've never met before that have confirmed these activities. We're not saying they don't happen. They have been happening.
Well, they're
So-
both unhappy with it, though.
I know they're not happy.
They're not speaking for you.
And I'm not in any way diminishing their concerns, because they have a right to enjoy their properties. But this is not a variance application where you're weighing the neighbors here. This is a strictly illegal
I understand,
interpretation.
but this is a public hearing, you have a right to speak.
Oh, of course they have a right to
Oh,
speak.
okay.
And they have legitimate gripes. I wouldn't want to live next door to this place.
Right.
Okay. All right? And we want to make it better.
Okay. If you want to present something like you're talking about, putting it inside a building or something like that, if you want to do it by next month to give us a rough sketch or something, or not enough
We
sketch.
have a plan.
Okay.
We'll show it to you. Yeah.
Present it to.
You have it now?
Oh, let's.
You
we don't
want to
need it
see it
now.
right now quickly?
No, give us time to look
No.
at it, but present
Can
it.
can you make copies of it?
All right. So can you
All right,
submit
go ahead,
it?
let's take a quick look at it.
Take
Go
a
ahead.
quick look and.
What time is it, 20 to 10? All right, take a quick look at it. Good thing we're getting paid by the hour here. Go ahead.
Introduce yourself.
We got more to go in on this?
No, just listen. Now, this is a plan to do what?
This is a plan to handle construction demolition debris. By the way, my name is Richard Galley. I'm a PE. I'm owner of a firm called Galley Engineering down on Long Island, and we do a lot of solid waste work with the Department of Environmental Conservation from Regions 1 to Region 4, which goes from Albany down onto Long Island. But the idea here is to put up a 25,000 square foot building, 30,000 square foot building with a new entrance onto,
What is it, 25,000 or 30,000?
well, this is a 25,000 square foot building, but it could go as high as 30,000.
Okay.
And we have it, we are calling for a new entrance into and out of the facility on Route 9 to come, to enter and leave the facility. But the idea would be to do, we bring the material in one end and process the material throughout the building and come out the other end with whatever the recycled product would be, which would be stored here, as well as any of the debris that there is sometimes residue that comes out of these facilities, and that has to be hauled away to landfill. And I do have a rendering of the facility to show you. The facility will be entirely enclosed, and we will have there'll be no trucks, there'll be no doors for anyone to see into the building from anywhere on Route 9. The idea is all the egress and exit will be through the west side of the property where we have these doors. The only door that there may be on either end will be a man door just to, for safety purposes in the event of a fire. But the idea is to have four doors, and that would allow us to be able to move material, trucks to come into the building. They'd be able to obtain the recyclables, bring them outside, or take them to the local recycler. And again, this is the view here. I know it's not in color, but it's a view looking from Route 9. So you could see that.
You're gonna put all those plantings in? or-
Yeah.
Okay.
Can I ask you, In the rock crushing and other processing of other materials, are there inhalants that are,
There will be ventilation fans here with, with filters on them. So we usually try to have 6 air changes an hour of the, I know what you're talking about, the
Right, I know,
crushing
but
of rock and
into-
silica.
into the adjoining neighborhood, is there, are there particles that are going to be,
These are gonna be fast opening doors, so when the truck comes in, the truck will, the doors will rise and they'll come down. These are full width, full height doors.
Right,
So the idea here is to keep all that exhaust, all of that crushing and any of that, that dust within the building. Plus there'll be a spray atomization system, which will be in the roof of, in the ceiling of the facility, which sprays a very fine atomized sprinkling of water, which then takes that dust and takes it out of the atmosphere, and it ends up on the floor and it ends up getting swept away as residue.
This is what the direction the DEC wants us to go. In fact, wants everybody in New York State to go this direction. In fact, there was a substantial change in the regulations last year.
November of 2017.
so this is required by the DEC?
This will be required by the DEC to
I
handle.
think we have another year and a half, and then
Yeah, we have to have
we
ourselves.
have to get
Yeah.
this approved. But we can't go to the planning board as long as your code enforcement officer has taken the position that we're not a legally non-conforming use. That's why we're here.
Right. Okay. Thank you very much. Yes, come on, come up.
Wayne Stevens, 33 Langate Road. If this is approved and this structure is built on this property site, would this be a permanent use that if the Venturas decided to sell, it would be transferred to a new owner? Or is it just a legal use for the in perpetuity for this owner?
Well, first of all, we don't approve that, okay? That would go to the planning board. We're talking about a legal issue now for this thing, but if it was approved and was built, and could he sell it to somebody else? Sure he could.
Okay, okay.
Why couldn't he?
Okay, thank you.
Okay. All right,
I'd like to
Sharon?
make a vote. Oh, Sharon? That's it?
Yeah, well, we're gonna put it off, we're gonna keep the public hearing open until next month, okay? And then you could have, you wanna have your other people testify, we could do that.
Second.
Second? All in favor?
Aye.
All right, thank you.